Hello, everyone. I'm Sara Raney, and I am not an attorney, but a victim like you. I am the proud mother of Dr. Kenley Gene Raney, who lost his life to a drunk on January 25th, 2019. Of course, as a mother, shock, trauma, and confusion became my world, even to this day. I have to admit, I believe I was in shock when I woke up to that telephone ringing. A voice on the line said, "There was a police officer outside who needed to talk to you." Now, there is only one reason why. As I was walking to the gate, I heard a police officer say, "Your son was involved in a crash, and he didn't make it. And it wasn't his fault. It was another damn drunk." How many people hear that? How many people hear that? My life, as I knew it, ended that morning. And I began a life sentence. I trusted the legal system, but only knew what I had seen on TV, which was not reality. The reality is that our loved ones' cases is only a case number, and that the DA works for the state, not us, the victims, and the criminals get all the rights. Believe me, you find out that more and more. Unless we, the victims, understand our rights and become a squeaky wheel. Because our rights are out there, but they're not always given to us, like in my case. One of the most frustrating things is how long everything takes. Because we have only seen it in the movies or in TV shows where it takes one person an hour to do everything. Well, we know that isn't true. But the trauma and the shock at that time, we're lucky we even know our names. We're walking around in a daze. But everybody around us will tell us that. But they don't expect us to be like that. They expect us to be normal. Think clearly. Understand what's going on. We know that isn't true. And whenever legal procedures, I never knew anybody that was ever in jail, probation. So how would I know what's happening next? Today I will discuss the 24 legal steps for DUI manslaughter cases. Now, if you add the grand jury, it is at 25 steps, but not all states have grand jury for DUI manslaughter. Now, this is very frustrating and confusing. However, it is even more so if you do not know it. For 11 long and frustrating months, I lived under the illusion that the man responsible for my son's death was behind bars. Why wouldn't he be? Why wouldn't he be? He was so drunk that he could not take the breathalyzer test. He was seatbelted in the driver's seat, and my son was asleep in a rest area. Why wouldn't he be? I mean, it's a simple reason. Why wouldn't he be if he's too drunk to take the breathalyzer test? Wouldn't that say that he was drunk? Well, not so. There was no doubt that he had murdered my child and was drunk. But that is not enough to get someone arrested and taken off the street in every state. In my mind, shaped by countless TV dramas, like I said before, my son's only experience with the police department was a Santa Clara County 911 supervisor. He never had a DUI, an accident, or, as far as I know, a ticket. He couldn't have become the youngest supervisor in Santa Clara County, over 50 people, if he had had any problems. I did not know anyone involved. I will say that again. Most of us do not. So how are we supposed to know? Whereas the criminal, like in my case, he was in and out of the law so many times, and probation so many, he knew how to circumvent the law. And also, too, he gets all the help, to include financial. It was a given. Take a life. Lose your freedom. Or at the very least, you're privileged to drive. Nope, he was allowed to drive. Yet reality shouted disbelief. I naively believed that the murderer was in jail or posted bond and was under the watchful eye of the probation officers. I was actually led to believe this. But he was free to drive, live as if nothing happened. He celebrated Valentine's Day, thanks to Christmas, while I cried at home alone. I also thought that the justice system was there to be for the victims. Another mistake. The criminal has all the rights. I've said this so many times, and it's so true. Is given money to pay for the DRAM devices or the IIDs and his attorneys, which I've discussed in other videos in detail. We are left with all our bills, shock, anger, everything alone. What they do, victims get, like I said, life sentence. We're fighting our rights and paying the bills. There is no financial relief or attorneys paid for by the state. And the DA's office is working for the state, not the victims. We are alone in this. Never forget this. Yes, there is victims compensation. Oh yeah. Which is a joke. It requires a lot of paperwork that you have to do while you're in trauma and shock. And so much other paperwork. The justice system wants you to fill out rounds of paperwork to get child's body and many other things. Let's not forget our daily responsibilities, such as work, bills, and emergencies. Life continues. Bills must be paid, and problems do not stop or take it back the seat. They're there in the forefront. Nobody cares. They want their money now. You cannot think clearly or remember things while fighting life and making sense of what has happened. At least I couldn't. You're in shock and trauma, and this never goes away. It only gets better. But it takes years. It's been 5 years, and today I had a breakdown. Here are these idiots that you have to deal with daily. Let's not forget the scammers that come out of the nowhere, or the relatives that come out of nowhere, or the ones that get a hold of your child's information and get a charge card, which is what happened to me too. I did not have to pay it because I could prove that my son was gone at that time and it wasn't his card. Now, the legal process, boy, that's another story. For convicting someone of DUI manslaughter involves several steps, which can vary by jurisdiction. Again, I do want to say again, over and over and over again, I am not an attorney. And the following information needs to be clarified and more manageable. It is only what I found on my research, not legal advice. Contact an attorney. In fact, get yourself a civil attorney. Now, let's talk about grand jury. Now, you've heard about that in the news so much lately. Well, in some states, for serious felonies, which is what mine was, the prosecutor presents evidence to a grand jury, which decides whether there is probable cause to indict the suspect. This step is crucial before formal charges can be brought in severe cases like mine. Now, the grand jury system is different than the others. It comprises of, grand jurors, prosecutor, witnesses, a court report, and a grand jury foreman, typically composed of 16 to 23 community members. The grand jurors evaluate evidence to decide if there is sufficient basis for criminal charges. Prosecutors and district attorneys present their case and guide the jurors on legal matters. Witnesses, including victims, eyewitnesses, police officers, and experts, testify to provide insight into the case. A court reporter documents the proceedings, ensuring a record that remains confidential unless disclosed during a trial. Now, the foreperson chosen among the jurors leads the group and communicates the jury's decision. This process is marked by confidentiality. With no public access, no defense attorneys, no criminal or judges present. Now, CVRA, the Crime Victims' Rights Act, which was initiated in 2004, says that you are allowed to attend all public hearings. The grand jury is not public, so you cannot attend that. In most cases, all victims should have, if you do attend any of these court trials, in most cases, all victims should have a safe room at the courthouse. That is a place where you can go to know that you will not be around anyone that is involved in the trial, such as the mothers, the fathers, or the defendants themselves. But when I asked a DEA's victims' rights person, she did not know where it was. And that is how I met face to face with the man and his mother who murdered my son on that infamous day, December 23rd, 2021. But I will tell you about that later. But let's talk about the 24 steps. Now, if you add a grand jury again, it's 25. Now, the first thing they do is, of course, at the crash site, the investigation. Now, this included 48 investigators in my son's case, to include latent fingerprint examiners, DNA experts, crash experts, and many more. And you sit there and you wonder why this all had to be done when it was so obvious that he did it. Well, the defense would try to find a reason to get a light sentence or overturn the trial, or in the future, try to get another trial. I have said over and over and over and over again, the criminal has all the rights. Now, after this is whenever the pretrial phase, after this is probably when the possible grand jury in some states might be held. Now, arrest. If there is probable cause to believe the individual was driving under the influence and caused a fatal accident, the suspect may be arrested. Now, it's obvious that all this happened. But he was not arrested that night because he was too drunk and had a boo-boo on his head. My son lay dead, crushed in a car. And this drunk had a boo-boo on his head, was taken to the hospital, and eventually released to his mother. What I understand while there, because he could not take a breathalyzer, the police officer that was involved in my case, did go down and get permission to take the blood test. Of course, in the future, the defense tried to say that the drunk was too drunk to give permission to take the blood test. So therefore, the results should be thrown out. It's just unbelievable and frustrating, the rights the criminal has. After that booking, well, fingerprints and photographs, which if you look on Google, you can find his picture. Then again, bail hearing. Oh, this is another one. The judge held a bail hearing to decide if the accused can be released from custody until he hit the trial and under what conditions. In my case, this was 11 months later, in November 2019. Now, bail means nothing unless the rules are enforced, and they were not. Preliminary hearing. The prosecution must show enough evidence to justify the charges and continue the legal process again. Pre-trial motions. Both parties may file motions to resolve legal questions and issues before the trial. Plea bargaining. Now this is the one you have to watch out for. Now the defense and the prosecutor may negotiate a plea deal in which the defendant agrees to plead guilty to a lesser charge in exchange for a more lenient sentence, which is what happened in my case. But this happened after all this others was done. Now this is also a way to get court cases off of the DA's desk. Please understand, the DAs have a lot of cases. Yours is just a case number, just another case. And a DA does not have to talk to you, the victim, about a plea deal. In most states, he can do that, or she can do that on her own without informing you. But I want you to think about this a little bit. All of us work. And sometimes we get so overworked. We have so many things on our desks that we start getting rid of things and doing the best we can on different, whatever it may be, do the best we can. But if we have somebody overlooking us or somebody coming and asking us why something's being done or why it isn't being done, we pay a lot of attention to that one and make sure we cross all our T's and dot all our I's. Please think about that when it comes to a plea deal. Then you have trial preparation, which is number 10. Yep, Brody, up number 10. Both sides prepare for the trial, including gathering evidence, interviewing witnesses, and formulating legal strategies. I thought this was all done in the grand jury. Then jury selection. If the trial is before a jury, the process of selecting jurors from the community occurs. It could also be a bench trial with no jury, and the judge makes the decision. Now again, that is the criminal's decision, not the victim. We have no right whatsoever. We can't say that we want a jury. That is their right. Everything is their rights. Presentation of evidence. Prosecutor presents evidence to prove the defendant's guilt beyond a reasonable doubt. Heck, he's so drunk, he can't take a breathalyzer test. He was seatbelted in his car. How much evidence do you need? Now, the defense presents the case, okay? Then there's closing arguments. Both sides summarize their cases and argue why the jury should find favor. Tell me. There's just so much evidence. Why wouldn't they find him guilty? Verdict. The jury presents a decision. If the verdict is not guilty, the defendant is released. If guilty, the process moves to sentencing. Now that's number 19. Pre-sentencing report. A report may be prepared to help the judge determine the appropriate sentence, often including the defendant's background and details about the offense. Background. Battery. Beating up his girlfriend, taking a baseball bat, or somebody, I don't know who that was. Skipping out on bond 2 times, one first time 6 months, second time 3 months. Open container. I wonder how many other times. This is what I found in the victim's portal. Please, sentencing report. Sentencing hearing. Sentencing. Appeal. He can appeal this. And this is where, well, the big deal with mine was the blood work. Post-conviction motions. That's 23. Defense may file motions challenging the conviction of the sentence, such as the motion for a new trial. I can't file anything if he's found not guilty. The victim has no rights. If the defendant is placed on probation, now here's what happened to me. There may be hearings to review or modify the probation conditions. This is a man who knew how to get away with probation without he didn't report in, he didn't do the urinalysis, he disappeared for 6 months and 3 months. He didn't get a DRAM device, he didn't get an ID. Believe me, those that have been arrested many times know how to get away with not following the rules with probation. They understand that there's so many people on probation that if they kind of just go behind the wall and disappear, they're going to be okay. And also to remember, DUI, in a lot of people's minds, is considered an accident. And the person who does that is not as dangerous as, say, somebody who takes a gun and shoots somebody or beats somebody up. Those are the facts. As a victim, I have chosen to take this horrific time in my life to honor my son, as I know that would be what he wanted me to do. There are days I cannot think straight, cry, get angry, and sit and rock back and forth on my chair. It's one of those days. Honestly, sometimes I want to go to sleep and not wake up. Then I hear my son say, "I love you, Mom. There's work for you to do." Please share your stories and help other victims going through this worst time in their lives. Together, we can help others navigate the legal system and get justice for our loved ones. Let's keep the conversation going for Kenley, Marshall, his beautiful dog, who died with him, actually. My son was crushed in the car, but the dog flew 500 feet. And every other soul taken too soon by these damn drunks. I am not an attorney, but I am the proud mother of Dr. Kenley Gene Raney, who was murdered by a drunk on January 25th, 2019. Thank you.